Good afternoon, everyone, and welcome to an unusual afternoon session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Torpy, and to my left is Judge Evander. We have all civil cases to be heard this afternoon, and the first case has come off the docket, so we are starting with the second case, which is KNOWLING versus MANAVOGLU, or some variation thereof, and there's a clock on the podium for you to keep your time. If you want help keeping an eye on time for rebuttal, just let me know, and I'm happy to try and do that for you. So we'll start now by calling the first case. Counsel can come up and begin when you're ready.
Thank you, Your Honor. And I've been on this case for 2 years, and I still cannot pronounce that last name either, so I understand.
Fair enough.
May it please the Court, my name is Henry Guyton with law firm Swope Redante, and I represent the appellant Helen KNOWLING, and I would like to reserve 5 minutes for rebuttal. Now, this case arises out of a motor vehicle accident that occurred on January 4, 2007 between a vehicle owned by and operated by Helen KNOWLING and a vehicle operated by appellee MANAVOGLU, and I'm butchering it, you know who I mean, and ANDTARKAN, MANAVOGLU. As a result of the accident, KNOWLING suffered severe injuries and property damage. Now, there are two issues on appeal. The first issue involves the trial court's granting of a final summary judgment in favor of the defendants as to their affirmative defense of settlement. Although KNOWLING alleges that the defendants, through their insurer, Allstate, failed to comply with the several conditions of the settlement offer made by KNOWLING, the trial court concluded that a binding settlement agreement was reached. The second issue on appeal concerns the trial court's failure to enter a final judgment reflecting that KNOWLING was entitled to $10,000 on her bodily injury claim in accordance with the alleged settlement agreement. The trial court entered a partial final judgment in favor of KNOWLING's, even though KNOWLING is still entitled to the $10,000, which she has not received. KNOWLING challenges both.
If we reverse on the first issue, that moots the second.
It moots the second issue, yes, Your Honor, correct.
I was a little unclear on what it was that the insurance company didn't send. Was it that they didn't send a copy of the policy, or did they not send an affidavit? What was it that they did not send?
They did not send a copy of the policy certified with an oath from a corporate official or a claim supervisor. Is
there a dispute about that, whether they sent it, or is that pretty well carved in stone?
There's no dispute that the policy that they sent, the affidavit with it, was from a claim support employee, which did not comply with the terms of the statute.
Is there anything in the record that would help us understand why it was that trial counsel hung on to the check for as long as he did? As I understand it, there was like 5 or 6 months that passed where the check was sent back.
There is no evidence in the record as to why it was held for that period of time. Presumably, counsel was consulting with the client, but I don't have any direct evidence or evidence I can point to.
You can only tell me what's in the record.
Right, of what actually occurred. And Your Honor, I guess to that point, to all the points, we would assert that those type of issues are really irrelevant. In this case, the offer was very specific. KNOWLING said that she was willing to settle her BI claim, her bodily injury claim, so she made that very specific up front. She said that the offer was expired within 60 days, and she required Allstate to send her a check for all available policy limits with all items described in Florida Statute 627.4137, and she attached a copy of the statute. She then said, send me a general bodily injury release of your insureds, and she specifically said that it needs to be ready for my signature, and that if that's all done, she will sign and those claims will be settled. And in the last sentence of the paragraph I'm quoting, she specifies that actual performance is required for acceptance. So this offer is very clear that this is a unilateral contract, that you can only accept it by performing it. And if you fail to perform, then you have not accepted the offer. We were not asking Allstate for a promise or an expression that it was willing to accept the offer or that it was going to try to perform. The offer demanded that Allstate and defendants actually perform. And they failed to perform in 4 distinct points. The first of which is that the release that they sent was not a bodily injury release. It was a release of all of Knowling's claim. And it was undisputed that she had a property damage claim that was a part of the complaint and that she ultimately did recover for in the final judgment. And if she had signed this release, it would have extinguished that claim. And I want to first focus on that because the defendant didn't even really address that in their brief, and there's really no dispute that the release that was sent would have encompassed more than just her bodily injury claim. That's undisputed. And it's undisputed that the offer specifically told Allstate to send a release of only the bodily injury claim. And it's our position that in failing to comply with that specific term of the offer, Allstate and defendant failed to properly accept the offer as a matter of law. This was a unilateral contract. Allstate could only accept it by performance. And under Florida law, if you fail to perform the requirements and conditions of a unilateral contract, no offer or no contract is formed as a matter of law. And there's a few cases that have dealt with that issue. One we cite is Schlosser versus Perez, which is at 832 Southern 2nd 179, second DCA case. And there the plaintiff sent an offer, much like this one, where they said we want all information required under the disclosure statute. And the offer specified that, please understand this settlement offer is intended as an offer for a unilateral contract which will be accepted only by strict performance. And what ultimately happened is that the insurer and the defendant there failed to send over or provide the plaintiff with the insurance disclosures as requested. And the court said, and I quote, generally an acceptance of an offer must be unconditional and identical with the terms of the offer. In this case, the trial court recognized that Schlosser's offer was not accepted on its terms, but the court concluded that those matters were not met, were of insignificant importance, or did not have anything to do with the real basis of this settlement and should not be a basis to deny enforcement of the settlement. That's what the trial court determined. The second DCA rejected that. The court said the term at issue in this case is the requirement that Perez or his insurer disclose the name and coverage of each insurer in compliance with the disclosure statute, and it is undisputed that neither Perez nor his insurer made the requested insurance disclosure. And for that reason, the court concluded that because Perez failed to provide the disclosure, his acceptance was not identical to the essential terms of the offer. Accordingly, the trial court erred in holding that the settlement agreement was enforceable. And that is our position here, is that the Allstate's attempted compliance with our offer was not what we asked for. It was not identical to the terms and conditions of our offer, and as a matter of law, no settlement agreement was enforced or could have been created. Another case that I would like to mention is one that I provided supplemental authority, which is Gonzalez versus Claywell, which is at 24 Southern 3rd, 1260, which is a first DCA case. In that case, it was very similar to the facts in this case, where through a series of letters, the plaintiff made an offer to settle, settling the bodily injury and property damage claim for a total of $26,000. In the offer, they asked for releases of only the insured, similar to our case, and not the insurer, just the insured. And the letter specified the offer would be open 30 days and that the offer could only be accepted by actual performance, as in this case. Now, in that case, Geico sent in a release and the checks, but the release that they sent included Geico as one of the releasees, which was contrary to the offer. The plaintiff rejected that, sent the check back, and Geico said, you know, that was just an unintentional mistake. We overlooked that. Let's send some new releases back. And I want to clarify or point out that in that case, they did send their letter, their kind of form letter, where they say, we don't think this release changes any of the material terms, and if there's anything wrong with this lease, let us know and we'll consider any changes that you want to make. So that this case involved the same type of letter that we have at issue here with Allstate. And the court, what they ultimately determined was that that GEICO failed to comply with the terms of the offer, even though it was, as they, even accepting that it was unintentional, and even accepting that they included this letter saying we were willing to change the release. The simple fact was that we wanted a release that did not include the insurer, and you sent us a release that did include the insurer. And even though you removed that and sent us another release, that constituted a counteroffer, not an acceptance of our offer, which the court concluded the plaintiff wasn't obligated to accept. So we think that case is directly on point with the facts of here, and we think it establishes that when you're dealing with a unilateral contract, there must be strict compliance with the terms of the offer, or no settlement is reached. Now, there are several other defects in Allstate's submittal to us that I wanted to point out. Not only was the release that they sent included claims beyond the bodily injury claim, it also included an indemnity and hold harmless provision that we never agreed to. And of importance, that provision included not only the insureds who we said we were willing to release, but it also included Allstate. So similar to the Gonzalez situation, they added Allstate to this indemnification and hold harmless provision, even though our offer was simply to the insureds only. There are a number of cases that recognize that an indemnification and hold harmless agreement is not the usual settlement documents. And the reason that is because such agreements impose upon the plaintiff an obligation to defend and possibly incur attorney's fees in defending third parties, which was something that we never agreed. And courts have recognized that because of the nature of such agreements, that those aren't usual settlement documents. That is essentially an extraordinary term that the insurers added, and then if there's no meeting of the minds as to whether or not the indemnification agreement should be included, then you have not formed a settlement. And we've cited several cases to that point in our brief. The third issue with the settlement dealt with the insurance disclosure, and as I mentioned before, the first issue was the fact that the only policy that they provided was sworn to by a claim support employee. And under 627.4137, subsection 1, it requires that the insurer provide a statement under oath of a corporate officer or the insurer's claims manager or superintendent. So that's what the statute required, and that's what we asked for, because we asked them to provide us with everything described within the statute. And again, Allstate failed to comply with that term of the offer. The last point that I would make is that Allstate also failed to comply with the term of the offer requiring that it provide a statement from its insured or its insurance agent as to other possible coverage that was never provided. In their brief, Allstate's position was that we had to make that request directly to the insured or the insurance agent. We believe that's a misinterpretation of Florida law, that the statute requires simply that the written request be made, and once it is made, and there's no dispute, we made that on Allstate. Allstate had the obligation to forward that to its insured and attempt to have them comply. But in any case, Your Honor, it's our position that it's really irrelevant why they didn't provide the insurance disclosure. The fact remains that they didn't, regardless of what the reason was for not doing so. And our offer required that they do so. And because they didn't, that was another instance where they failed to actually perform the terms of our offer. So in sum, Your Honor, we believe that under well-established Florida law, a unilateral contract requires actual performance to create a contract. The trial court failed to recognize that fact and instead was misled by Allstate's self-serving letters suggesting that they were willing to change the terms of the release. But again, under Florida law, it doesn't matter whether they make a promise to perform or are willing to perform. The only question is whether they actually performed. And in this case, it's undisputed that they didn't. We also have an issue regarding the final judgment. In the interest of time, I will rely on my brief for the argument as to the court's error in not entering a final judgment for $10,000. I did, however, want to speak on the motion for attorney's fees because we believe as a matter of law, the attorney's fees, the proposal settlement that Allstate provided was not made in good faith. Essentially, Allstate, knowing that it owed us $10,000, submitted a proposal for settlement for $10,000. And in fact, if we had accepted that settlement, we would have gotten less than $10,000 because our offer was for $10,000, which was the policy limits, excluding our property damage claim. So we had another $1,000 or so of property damage claim. The proposal for settlement was for $10,000 as to all our claims. So if we had accepted that proposal for settlement, we actually would have gotten less money than we would have gotten under the terms of the offer. And we would assert as a matter of law that that cannot be in good faith. It wasn't even an issue of them offering us $0. They offered us negative dollars because they wanted us to agree to waive our property damage claim. So we believe under the statute that proposal for settlement was not made in good faith, and we also think that it by that provision made it ambiguous, which is another basis for finding that it cannot support an award of attorney's fees. So while we believe we should win this appeal, if this court ultimately disagrees as to the issue of attorney's fees, we believe that also.
You're kind of losing me on
I'm
this.
sorry.
The attorney's fee issue, this is an issue you raised in your brief? Or?
This wasn't, there was a separate motion for attorney's fees. I just wanted to address it. I don't.
Oh, a motion for attorney's fees
Yes,
on
sir.
appeal?
This
is your response to
This
that?
is my response to it. I just wanted, because I wanted to get the
You're talking about
opportunity.
attorney's fees below, you're talking about...
Correct, Your Honor. I apologize. I should have clarified
No problem.
that.
Okay.
I should have clarified that earlier. I just wanted to respond to that. But I will reserve the remainder of my time for rebuttal.
You have about 3.5 minutes.
Okay, thank you.
May it please the Court, Mark Tinker on behalf of the Manavoglus. Just to respond to the last issue first regarding the attorney's fees, I think to the extent that that is an issue, I think that's something that would need to be addressed by the trial court first as far as whether
That's what
an offer was made.
what we usually do, is remand it for the trial judge to determine entitlement and amount. Go ahead with the other issues.
Yes, Your Honor. I think, from what you said at the outset, Judge Torpy, was everything sent. And I think I disagree with counsel. I think the record is clear that everything that was asked for in the offer was sent. The insurance disclosures, a copy of the policy. There's no dispute, and this was all done on stipulated facts below. There's no dispute that everything was received, and everything was received within the 60-day time frame.
This letter that I'm looking at, May 23rd, 2007, page 2, seems to have a pretty succinct little statement here of what they want. If you just send a check for all available policy limits with all items described in Florida Statute 627-41-37 attached, and a general BI release of your insurance ready for my client's signature, she will sign it, and those claims will be settled. Actual performance is required for acceptance. Did you do all these things? Did your client do all these things here that is set forth in that?
I believe so, and I think and this is what the Judge Cast actually looked at below, is he said, you just asking for a general release. You don't describe what can be in it.
Well, it says a general BI release. We all know what BI means, right?
Correct. And I think the issue is, what you have here is you have an attorney asking an insurance adjuster, you send me the legally binding document. You draft it, you be in charge of it. And what the response was, here's my best effort at it. This is what I think complies with your request. If there's anything about it that does not comply, let me know and we'll revise it.
Well, how can it be a best effort if there's two claims and their proposal is for $10,000 as full settlement of one claim, and you submit a proposed release which settles both claims? And what if the property damage in this case was $50,000? And so they said, look, we'll settle the bodily injury for $10,000. And you send them a release saying, which in essence says you give up your whole claim for $10,000. Isn't there a failure of meeting of the minds?
No, because again, the letter that came along with it said, if there's anything about this release that does not comport with your offer, or comport with the settlement, let me know and we will revise it. And I think there's a couple of
So is
important
this a
issues.
general bodily injury release, or is this a general release?
That goes to exactly what Judge Kessler was saying, is what is a general release? I mean, he just left it up to the adjuster to draft it. And if you look at the
They didn't
two
ask for general
things,
release.
well, that's what
They
was
asked for
sent.
general release of a bodily injury claim.
And what was sent was, if you look at the check itself, the check stub says, here's the $10,000 for your claim arising from bodily injury. So they're saying, here's your bodily injury claim, here's the release, and I think
If they'd have signed that release, they'd have been out on their property damage claim, right?
I believe that would be a fair reading of the release, yes.
So at the best case scenario from your perspective is that we all just didn't have any kind of meeting of the minds on what was meant by general release. They sent us a request for it, we sent it back, this is what we thought should be in it, and we told them that if they didn't like what was in it, they could change it. That doesn't make a contract, does it? That makes...
It does, because the only essential term there is, I'm going to give you a general release. And as far as what are the exact terms of that, is it going to include an indemnity or hold harmless language? Is it going to include, rights to attorney's fees if somebody breaches? Is it going to
wasn't
include any
ready
of
for
those things?
signature, was it? Was it ready for signature?
It was, if that was acceptable.
Ready
If
for
it was not
signature
acceptable,
After a lot of deletions, it was ready for signature, right?
if it was not acceptable, also it said, we will send you one that complies. We will send you one that is revised to reflect the exact terms of your agreement. So yes, this one was ready for signature.
How is
if
that
you
not a
wanted to.
counter proposal?
It's not a counter proposal because it's saying, we agree, we're going to supply you exactly what you're asking for. Here's a proposed version. If that's not what you want, let me know and we'll revise it so we give you exactly what you want. And that's
It didn't say you would
precisely
give
the
them
letter.
exactly what they want. It said that you would consider it.
No, it says, and this is, I think the key is the last sentence, if you feel that there is any aspect of the enclosed document which does not reflect our settlement of your claim, please contact me immediately so that we can see that the document is revised to reflect the exact terms of our agreement. And that's the direct quote from the letter, saying if there's any aspect of it that doesn't comply, let me know, we'll revise it.
Well, in essence, what you propose to do then is to comply with the unilateral contract, not by performing, but by entering into a discussion about what might constitute performance.
It is performance because they didn't say exactly what the terms of the release need to be. They said, just send me a general release.
They
And
said
so it is
this-
performing.
But you keep leaving out the BI. You keep leaving out bodily injury. You did not send them a bodily injury release.
Right, and I can't dispute that, and that's why the letter says, if there's any aspect of this, they say, oh, there's an oversight in there, you didn't limit it to BI, you put possible property damage or other claims in there, we will, it's performance saying, yes, here's everything you want, if this isn't exactly what you want, we will give you everything you want, we're doing that. And that's what I think the letter has to be read in conjunction with the release. They were all sent as part of one package, saying, you asked for a general release, this is what our proposal is of what you think a general release is supposed to look like if that's not it.
General BI release.
Correct. And this is what the insurance adjuster said, I think this is what you're looking for. If it's not, let me know and I'll revise it. And it's easily done. And I think...
Well, so your contention that the preparation of the release was a ministerial act? And so
as far
we're
as what
talking
the
about-
precise terms of it are going to be, yes. Because the offer didn't say, we want these precise terms.
The problem I'm having with ministerial, and so you're going to need to convince me, is when they want $10,000 of settlement for one claim and you submit a response offering to pay $10,000 to settle two claims, how is that simply ministerial?
That's not what the response was. The response, again, the check said, here's your $10,000 for your bodily injury claim, and here's a proposed release. If we think this is what you're looking for, if it's not, we'll revise it to make sure it's exactly what you're looking for. So that's the ministerial part, is what are the precise terms of this document going to be that you're going to sign. The important term is we're going to sign a general release. This is just a proposed one.
Do you think there's a difference between a general release and a general release as to one claim?
Do I personally? I think that, yes, there can be a difference. You can have all different types of releases.
So they asked for a general release as to one claim, and they asked for performance as part of the settlement. Was there ever a general release only as to one claim sent to them?
There was No, it wasn't apparently exactly what they were looking for. There was a proposed release with the addendum to it saying, if this is not exactly what you want as to that one claim, we'll make it so. And I think, when it comes down to everything, what is going on here and what's obvious behind the scenes is this is essentially a bad faith setup case where make a most ambiguous offer, say, send me your release. The return release, they could object to anything in it. And I think that's part of what's here as well. There's indemnity and hold harmless language. We didn't want that in there. Well, it didn't say send me a general BI release with no indemnity and hold harmless language. It didn't start listing out what was supposed to be there. It left it up to the adjuster saying, you send me what you think is going to be compliance. And that's what the adjuster did here, was submit the proposed release with the qualification that I'll make it say anything you want it to say.
What's your response to the Nichols versus Hartford Insurance Company case? You didn't address it in your answer brief. That's the one that says an indemnity and a hold harmless agreement is a material deviation. I believe the issue there, again, is if you look at what was asked for, they didn't say, send me a release with no indemnity. And that was precisely what Judge Kess got at the hearing. He said, you didn't ask for that. How is an insurance adjuster supposed to know that a general release to you means one that does not include that's a material term to you? And I think that's one of the things, if you look at Nichols, you have to be specific to each case and the facts of each case. What was their offer? Well, in the Nichols case, they sent an indemnity and hold harmless that included a lien just like this one. And the court said that's a material deviation. Anybody should know it's a material deviation. Therefore, there was no meeting of the minds and there was no settlement agreement.
And I think
and that was back in 2002. Surely the insurance company knew that.
And I think the key thing, I just have to keep going back to it, is the letter saying if there is anything here that you think is material and you think changes what it is that you're wanting, we'll revise the release to reflect it. So I don't believe Nichols.
So you could have put in there, here's your general release, here's your $10,000, and we'd like for you to take the adjuster to dinner at a nice steakhouse in Orlando. But if that's not okay with you, just let us know. And that's a contract, huh?
If the offer says, just send me what you think a general release is, I believe that could be a contract.
No, my hypothetical, is that a contract?
I believe it is if the terms of the offer are just send me a general release. I mean, we could sit here and say, well, everybody's supposed to know what the terms of a general release are. And I think, that was pressed both in the trial court and in the briefing here, is there's never been a definition. What is a general release? What does that mean? It's something that was left up to the adjuster. They said, here's my proposed release. Revise it to say exactly what you think you need.
Well, I think you've already agreed that a general bodily injury release does not include a property damage release. You've already agreed with that.
I agree that those can be distinguishable, yes.
Okay.
I think, again, I feel like I would just be repeating myself to go any further with the argument. I think it comes down to the cover letter and saying you're free to revise it to reflect whatever the terms are.
We understand your argument.
Thank you. If the court has no further questions, I'll yield my time.
Thank you, sir.
Thank you.
Your Honor, just briefly, as to the issue of whether this was a ministerial act, Florida law is clear that that terms of an offer are essential terms. In our offer, we said we want you to send us a general bodily injury release. And if Allstate knew nothing else about this release, they knew that it needed to only cover bodily injury. They knew it only needed to cover their insurers. They knew that they needed to send all the described disclosures from the statute, and they knew that they needed to have that release ready for my client's signature. They knew that. This is not complicated. We aren't arguing about them putting in some therefore or some other ambiguous provision. We're arguing that you didn't comply with the specific thing that we asked for. And the way they've excused it, or the way Judge Kess, and he brought into this argument, is they said, well, we just included this letter that pretty much says, if you don't think this is right, send us something and we'll look at it and decide, if we agree with you, and we'll send it back. That wasn't our offer. Our offer was not to enter into negotiations. Our offer was
But there really is no canned general release, right? There's no such thing. It's unless you say that it's the Ramco form, general release, or the, or the Florida bar, Form 1 or something like that.
And I understand that, Your Honor, but I think the case law is clear that the indemnification and hold harmless provision is not a part of a general release. And I think even if you ignore that, we clarified that we wanted a bodily injury relief, and I think that is fairly understandable.
It's always better just to say, here's the release I'm willing to sign, and put the language in there, and attach that to the proposal, and attach that to offers of judgment, and get that all ironed out on the front end.
I mean, that is something that could have been done, but there's no requirement. We're not even required to make an offer. I mean, we can set up an offer the way we want to, and I think Allstate's position can be summed up in like this. It's like if I could say, give me a red notebook, and I'll give in 10 days, and I'll give you $1,000. And essentially, instead of sending me a red note, but I say, and I clarify, the actual performance is required. And instead of sending me a red notebook, they send me a notebook that's a rainbow color, that's red, blue, green, orange, and they attach a letter to it saying, well, this is what we think complies, but if it doesn't comply, you make what changes you want and send it back to me. So now I'm supposed to be obligated to now write out the different colors that are different than what I require, paint the whole notebook red, and then send it back to them for them to look at it and say, yeah, we agree with this, and then send it back to me. That's not my offer. And that is essentially what their position is. Our offer was for a unilateral contract requiring actual performance. And I think Florida law is fairly clear that if you make that offer, that the actual performance is required before you can create a binding contract. So in sum, all we're asking this court to do is to follow Florida law. The trial court, I believe, got confused because he confused this with a bilateral contract where you just exchange promises, failing to recognize that the key issue was performance. And for that reason, we believe that this court should reverse. Thank you.
Thank you, Mr. Adams. Thank you, counsel. The next case is Stefanski versus Weatherguard.